The user wants a pure prose script. No UI needed. I'll write the script directly. Laughs. She laughed. That was the first thing anyone noticed. Not a nervous laugh, not an uncomfortable laugh. A full, bright, performative laugh. The kind that fills a room and dares the room to say something about it. Vivian Hartwell, 26 years old, daughter of U.S. Senator Douglas Hartwell of Virginia, sat at the defendant's table in Courtroom 14 of the Mecklenburg County Superior Court, and she laughed. The plaintiff, a 31-year-old kindergarten teacher named Rosa Medina, whose hands were trembling so badly she had to press them flat against her thighs, turned to look. The jury turned to look. Every journalist in the gallery turned to look. And then, for exactly 20 seconds, the entire room went so completely, so utterly, so devastatingly silent that you could hear the fluorescent lights humming above the mahogany bench. Because Judge Anita Wren had looked up from her notes, and when Judge Anita Wren looked up, the world stopped. Before we go any further, if you have ever believed that power without conscience eventually meets something it cannot buy, charm, or escape, drop a comment below, because what happened in Courtroom 14 on that Tuesday morning in October is the kind of story that doesn't let you go. Share this with someone who needs to see it. We are just getting started. The case had begun, on paper at least, as a civil dispute over property damage. That was what Vivienne's attorney, a silver-haired man named Gerald Fitch, who billed at $600 an hour and wore cufflinks shaped like the scales of justice, had filed it as. Property damage and emotional distress counterclaimed against Rosa Medina, who had allegedly allowed water from a burst pipe in her rented apartment to seep through the walls and damage the hardwood floors in the unit below, which Vivienne Hartwell owned. The repair estimate, submitted by a contractor whose business cards listed him as a premium restoration specialist, was $94,000 for floors. Rosa Medina's annual salary, before taxes, was $38,500. She had moved into the building 18 months earlier, fresh from a divorce, her 2 daughters, ages 7 and 9, sleeping in the second bedroom on a mattress she had driven across 2 states. She worked at Pinewood Elementary. Her students called her Miss Rosa. She brought homemade tamales to school on Fridays. She had never been inside a courtroom before that Tuesday, and when she walked through the double doors, she was wearing a blazer she had borrowed from her sister, navy blue with a small gold button at the collar, and she was holding a manila folder so tightly its edges had bent. Vivienne Hartwell had arrived in a cream-colored cashmere coat, a leather Birkin bag in cognac resting on the table beside her laptop, and an expression of mild inconvenience, as though this courtroom, these people, this entire proceeding were a delay she was tolerating on the way to something more important. She sat with her legs crossed, one heel bouncing slightly, and spent the first half hour of the hearing scrolling through her phone under the table with the practiced discretion of someone who had never once been told to stop. Gerald Fitch opened with polish and precision. The water damage was real, documented, and severe. The contractor's invoices were presented. Photographs of the floor, warped, bubbled, discolored, were submitted. The hardwood, Fitch explained, was artisan-laid white oak, sourced from a Vermont mill, irreplaceable in its character. He said the word irreplaceable with genuine feeling. Rosa's attorney, a young public interest lawyer named Daniel Osei, who had graduated 3 years ago and whose suit was slightly too large at the shoulders, rose and spoke quietly. His client had reported the pipe to building management 5 times over a 4-month period. He had the maintenance request logs. He had the emails. He had, in fact, a certified letter Rosa had sent to the building manager, dated 6 weeks before the pipe finally burst, in which she wrote, and he read this aloud slowly, "I am begging you to please send someone. My daughters and I can hear the water running inside the wall. I am afraid of what will happen." The courtroom shifted. A woman in the 3rd row of the gallery pressed her lips together. One juror, a retired postal worker in a gray cardigan, turned to look at Rosa Medina. Rosa was looking at the floor. That was when Vivian laughed, not at anything that had been said in the last 10 seconds. She had been reading something on her phone, and something on her phone had apparently been funny, and she laughed, and she did not look up, and she did not seem to notice, or perhaps did not care, that every person in that room had just heard the evidence that her tenant had begged in writing for help 6 weeks before a disaster that was now being used to sue that same tenant for $94,000. Judge Wren set down her pen. The room went silent. 20 seconds passed. "Ms. Hartwell," Judge Wren said. Her voice was exactly the same volume as a normal conversation. That was the thing about Judge Wren. She never needed volume. Volume was for people who were not certain they would be obeyed. "You are in my courtroom. While you are in my courtroom, you will give it your complete attention. Do you understand me?" Vivienne looked up. For just a moment, one flicker of a moment, something uncertain crossed her face. Then it was gone, replaced by a polished, cooperative smile. "Of course, Your Honor. My apologies." "That apology," Judge Wren said, picking up her pen again, "was not for me." The room exhaled. Gerald Fitch moved quickly to regain ground. He called the premium restoration contractor to the stand, a broad man named Kevin Stills, who spoke with authority about moisture infiltration patterns and tongue-and-groove installation costs and the particular tragedy of damaged Vermont white oak. He spoke for 40 minutes. He was convincing. He had charts. Daniel Osei cross-examined him for 11 minutes. He began by asking Mr. Stills how long he had been in the restoration business. 14 years, Stills said. He asked how many projects Stills had completed for properties owned or managed by entities connected to the Hartwell family or Hartwell Capital Holdings. Stills blinked. 1 or 2, he said. Daniel Osei placed a document on the overhead projector. It was a list. It had 23 line items on it, spanning 7 years, totaling slightly over $1.2 million in work. He asked Mr. Stills if he would like to revise his answer. Stills said he would need to review his records. Osei said politely that he would wait. The courtroom was very quiet. Judge Wren was writing something down. She wrote for a long time without looking up. Fitch objected on the grounds of relevance. Judge Wren, still writing, said without raising her eyes, "Overruled. Relevance is becoming quite apparent, Mr. Fitch." She finally looked up, not at Fitch, but at the contractor on the stand, and she said, "Mr. Stills, is there any number on that list that was assessed, reviewed, or approved by an independent third party before payment?" Stills said he wasn't sure. She said, "That was not actually a question with an uncertain answer. Please think carefully." He said no. Osei moved to his second exhibit. It was an independent assessment, commissioned by Rosa Medina's legal team from a licensed structural engineer not connected to any Hartwell entity. That assessment valued the floor damage, accounting for the actual material, labor, and scope, at $11,200. The courtroom heard this number and then heard the $94,000 number again in their minds, and the distance between those two figures hung in the air like smoke. Fitch was on his feet immediately. The independent assessment was outside the contracted specialist's expertise. The methodology was flawed. The materials had unique characteristics not reflected in standard market pricing. He was smooth, fast, and professional, and none of it mattered because the woman in the front gallery who had pressed her lips together earlier had now covered her mouth entirely, and the retired postal worker was shaking his head, slowly, without appearing to realize he was doing it. That was when Vivienne Hartwell made her first real mistake. She leaned toward Fitch during a brief recess, not quite a whisper, not quite a normal voice, the volume of someone who has spent a lifetime in rooms where other people's presence registered only as background, and she said, "This is embarrassing. Can we just write her a check for whatever and be done with it? I have a thing in Charlotte at 4. She had said it to her attorney. But the acoustics of Courtroom 14 were exceptional. Daniel Osei heard it. 2 jurors heard it. A court reporter heard it. And the woman directly behind the defense table, a woman who had not been introduced yet, but who would be called to the stand within the next 30 minutes, heard every word. Her name was Margaret Tully. She was 64 years old. She had lived in the same building as Rosa Medina, 2 floors above, for 11 years. She walked to the stand slowly, steadily, wearing a house dress and orthopedic shoes and an expression of complete moral calm. Osei asked her what she had observed during the months before the pipe burst. She described, without drama or embellishment, the sound she had heard, the dripping, the wall that had begun to bulge slightly near the second-floor bathroom, the conversation she had heard between Rosa and the building super, which always ended the same way, with the super saying he had submitted the request and was waiting on management. She described the morning the pipe finally gave, the sound of water, the panic in Rosa's voice, her daughters crying in the hallway while Rosa knocked on doors to warn her neighbors. Fitch's cross-examination of Margaret Tully lasted 2 minutes. It did not go well for him. Then Osei asked the question that changed everything. He asked Margaret if, during her 11 years in the building, she had ever experienced maintenance issues that went unaddressed. Margaret said yes. He asked if she could describe the pattern. She could. Over 7 years, she had cataloged every maintenance request she had ever submitted. She produced a spiral notebook from her bag, neat handwriting, dates in the margins, and of 61 requests, 47 had been ignored, deprioritized, or addressed only after damage had already occurred. He asked her what the building management's response typically was when she followed up. She said, "They told me the unit owner had to approve all repair expenses above a certain threshold." He asked who the unit owner was. She said, "Ms. Hartwell's family company, Hartwell Capital Holdings." The courtroom did not gasp. It did something worse. It went completely, profoundly silent, the way a room goes silent when something has just been understood by everyone at the same time. Judge Wren looked up from her notes. She looked at Gerald Fitch. She said, "Mr. Fitch, your client's family company owns this building?" Fitch said yes, through a property management subsidiary. She said, "And your client filed a civil action against her own tenant for damages that resulted from a maintenance failure requiring approval from your client's own family company." Fitch began to explain the structural separation between ownership entities. Judge Wren said, "I understand corporate structure, Mr. Fitch. I'm asking whether you understand irony." A single involuntary sound escaped from somewhere in the gallery. It was immediately suppressed. Osei had 3 more pieces of evidence. The first was a series of text messages subpoenaed from the building management company's internal communications, in which the maintenance request submitted by Rosa Medina had been flagged with a note that read, "Hold. Owner wants to assess whether tenant is worth the spend." The messages were dated 4 months before the pipe burst. The second was a financial record showing that Hartwell Capital Holdings had, in the same fiscal quarter, denied 12 separate maintenance requests across 3 properties, while reporting a 12% increase in net rental income. The third was a deposition from a former property manager who had left the company 8 months earlier and who stated, on the record, that he had been verbally instructed by a senior Hartwell Capital director to delay non-urgent repairs in tenant-occupied units until lease renewal to create leverage. Daniel Osei put down his folder. He looked at the judge. He said, "No further witnesses, Your Honor." The room was very still. Judge Wren removed her reading glasses and set them on the bench. She looked at Vivian Hartwell, not with anger, not with contempt, but with the precise measured attention of someone who has seen this before, has always seen this before, and is no longer surprised, but remains, nonetheless, unwilling to let it pass. "Miss Hartwell," she began, and her voice had the quality of a door closing, the quiet finality of something being sealed. "You came into this courtroom today to collect $94,000 from a woman who earns $38,500 a year. You came with an attorney, a fabricated invoice, and what I can only describe as remarkable confidence. I want to address that confidence directly." She stood slightly, not all the way, just enough to change the geometry of the room. "What has been presented before this court today is not a property dispute. It is a document of contempt. Contempt for a tenant who begged for help. Contempt for a legal process you clearly regarded as an inconvenience between appointments. And contempt, most corrosively, for the idea that the rules which govern the rest of this society apply with equal force to people with your last name." Vivian was very still. The casual posture was gone. The phone was gone. She sat with both hands flat on the table and her eyes fixed on the judge, and she looked, for the first time, her actual age. "You said something during the recess today," Judge Wren continued. "You said, and I quote, because I want the record to be precise, Can we just write her a check for whatever and be done with it? I have a thing in Charlotte at 4. I want you to understand what was in that sentence. In that sentence, a woman's financial devastation, her dignity, her daughter's security, her borrowed blazer, and her 5 months of terror were reduced to the word whatever. And I want you to understand, clearly, permanently, and without any ambiguity, that courts of law exist precisely to ensure that whatever has a number, and that number is not arrived at by the people who cause the harm. The courtroom had not moved. No one had shifted, coughed, or breathed too loudly in several minutes. I am not here, Judge Wren said quietly, to punish you for being rich. I am here because the law does not negotiate with leverage. It does not adjust itself for Birkin bags or last names or Charlotte appointments. And on the days when it almost does, on the days when someone believes it will, it is my particular honor to be sitting in this chair. She picked up her glasses. She looked at her notes one final time. Then she looked at Rosa Medina. Rosa was sitting perfectly straight. She had stopped pressing her hands against her thighs. Her eyes were bright. This court finds entirely in favor of the plaintiff, Rosa Medina. The counterclaim is dismissed in its entirety. Ms. Medina is awarded actual damages in the amount of $11,200, reflective of the independent assessment, for any incidental costs associated with this litigation and displacement. Additionally, this court refers the conduct of Hartwell Capital Holdings to the State Attorney General's Office for investigation into potential violations of the Residential Tenant Protection Act across all managed properties. The contractor, Kevin Stills, is referred to the licensing board, and Gerald Fitch. She paused and looked at him with something that was almost pity. Your billing rate does not insulate you from bar review. This court is scheduling a separate proceeding to examine the submission of a fraudulent invoice as evidentiary material. You will receive notice. Fitch had gone pale. Vivian Hartwell was staring at the table. Judge Wren removed her glasses again. She said almost gently, Ms. Hartwell, your father is a senator. Your family company manages 11 residential properties in this county. You have resources, connections, and opportunity that most people in this state will never touch. I sincerely hope that what happened in this room today is the beginning of something different for you, because consequence, real consequence, has a way of being educational when everything else has failed to be. She stood. This court is adjourned. The gavel came down once, clean and final, like a period at the end of a very long sentence. Rosa Medina did not cheer. She did not cry, not right away. She sat completely still for a moment, and then she slowly turned to Daniel Osei, who was trying very hard to maintain professional composure and not entirely succeeding, and she said something to him quietly. He nodded. He put his hand briefly over hers. The woman in the gallery, the one who had covered her mouth, was crying openly now. Margaret Tully, walking past the plaintiff's table on her way out, stopped and placed her hand on Rosa's shoulder and squeezed once without saying anything, and then walked on. Vivian Hartwell sat at the defense table for several minutes after everyone else had begun to move. Her cashmere coat was still draped over the chair beside her. The cognac Birkin was still on the table. She sat with her hands in her lap, and she looked at a fixed point on the wall, and she did not look like someone who was angry, or planning an appeal, or already on the phone with a crisis PR firm, though all of those things would come later. She looked, in that moment, like someone who was seeing something for the first time. What exactly that thing was, the limits of her protection, the reality of another person's suffering, the sight of her own reflection in a proceeding she had tried to reduce to a footnote, was not possible to say, but it was something. The room had insisted on something. In the weeks that followed, the Attorney General's investigation into Hartwell Capital Holdings expanded to include all 11 properties. Building inspectors were sent. Maintenance logs were subpoenaed. 3 other tenants, a single father, an elderly couple, and a woman who worked 2 jobs at the same time, came forward with their own documented histories of ignored requests and manufactured delays. A class action was filed 4 months later by a consumer protection nonprofit on behalf of 62 current and former Hartwell Capital tenants. The case was settled out of court for an amount the nonprofit described publicly as significant. The terms were sealed, but the building on Rosa Street received a full plumbing overhaul, new insulation, and a management company that returned phone calls. Kevin Stills lost his contractor's license in February. Gerald Fitch received a formal reprimand and a 60-day suspension, reduced from 90 after a character review. He quietly stepped back from litigation work and moved into estate planning, where presumably the floors were less contested. Rosa Medina stayed in her apartment. She bought her daughters a new mattress, a real one with a frame. She kept the navy blazer even after she returned it to her sister, and her sister said she could keep it. She still brings tamales on Fridays. She told a colleague later that the hardest thing about that day was not the fear, not the borrowed blazer, not even the year and a half of uncertainty. The hardest thing, she said, was walking into a courtroom full of people and not knowing whether the system was going to see her. And then, she said quietly, it did. As for Senator Douglas Hartwell, he declined to comment on the case publicly. His office released a statement saying the family respected the court's decision and was cooperating with all relevant inquiries. He did not seek re-election to his Senate seat when his term ended. Whether that was connected to what happened in Courtroom 14 on a Tuesday morning in October, no one has said officially. But the people who knew him said he came home different that fall, quieter, like a man who had been made to sit in the room where the bill for something finally came due. Judge Anita Wren was asked about the case in an interview the following spring. The interviewer asked whether she found satisfaction in rulings like this one. She was quiet for a moment. Then she said, "I don't find satisfaction, I find resolution. Satisfaction implies it was never supposed to happen. Resolution means we corrected it. My job is resolution. The rest is just furniture." She smiled a small, precise smile. Then she picked up her reading glasses and she went back to work. If this story moved you, if you believe that dignity is not a luxury reserved for people with the right last name, leave a comment below. Tell us what hit hardest. Was it the borrowed blazer, the word whatever, the notebook Margaret Tully had kept for 11 years? This is a channel where those details matter, where the quiet heroism of ordinary people sitting up straight in borrowed blazers gets to be the headline. Subscribe if you want to see more of the stories that courts actually produced, the ones where something real happened, where the gavel meant something, where the system worked the way it was supposed to work. And if you know someone who needs to hear this today, someone fighting to be seen, someone sitting with their hands pressed flat against their thighs trying not to shake, share this with them. Because sometimes the most important thing is just knowing that the room eventually went silent and that the silence was hers.